Welcome back to Building Up Your Business, the podcast. I'm your host, Erica Dill from Operationally Up. From bombs to order fulfillment, taxes to marketing, learn the stuff from the professionals before you step in it. I'm really excited today to have Renee Noy with us. She spent 13 years representing employees in employment disputes and decided to use her legal expertise and experience to help companies. Renee now owns WorkWise Law, specializing in helping companies stay in compliance with California and federal employment laws. And my goodness, California laws are a doozy, so you must be a master. Thank you so much for joining us today, Renee.
Thank you so much for having me, Erica. I appreciate that.
Well, today, Renee, oh geez, here we go. I'm going to combine your names. It's going to be great. It's a great episode. I can never talk. Renee is here to join and talk to us about the top 5 mistakes business owners are making when it comes to employment law. And this is one of the topics that I think is super important for all companies, no matter their size, because it's inevitable, and Renee, you might agree or disagree with me, I'd love to hear it, but it's inevitable that at some point companies are going to run up against some sort of employment law issue, correct?
Seemingly, yes.
Yeah, unfortunately, that seems to be the case. So let's dive right into the topic. So Renee, give us a little background. We're saying that potentially, most likely, they're going to run into some sort of scenario. How much could a company, predict or should consider that it would cost them if their revenue is, say, 60 million or below? How much is that employment dispute going to cost them?
Okay. Well, let me kind of break down your question, because there's kind of 2 questions in there. So first of all, I only deal with companies typically that have run into some issue. And so I'm sure there are, and I tell my clients all the time, there are plenty of companies out there that have been running for 30, 40, 50 years, and they've been very, very lucky. The problem is that in California, employees are getting extraordinarily savvy, and there's incredible resources out there on social media that tells employees what their rights are. And, just like driving to Vegas or to Palm Springs, you see billboards everywhere, get into a car accident, call this number, and there's personal injury lawyers advertising like crazy. Well, that's kind of what the employment world has turned into. So now, are you an employee? Were you fired? You have rights. Call 1-800, you have rights. And so that's why there's just been this unbelievable plethora explosion of employment cases. So it's getting harder and harder to be that lucky employer that just kind of avoids a lawsuit or avoids employee issues the entire course of their company. But it happens. So I don't want to be super pessimistic. You can probably get away with it. But I think the most disheartening part is that so many, especially the clients that come to us just for compliance reasons, they're like, we know that there's so much out there we don't know. We want to be we want to make sure that we are following all these laws. And so then I start working with them, and still you get employees that will bring a frivolous lawsuit against them that really has no merit. And they could be 100% correct in the way that they ran the business and the way they were managing their employees. They still have to defend a lawsuit, because once that lawsuit's filed, you can't just ignore it and say, no, I did nothing wrong. You have to show that you did nothing wrong, and it costs money. So to answer your question about like the $60 billion, whatever the number was, revenue, it really doesn't make a difference. A lawsuit is a lawsuit. If you're dealing with a wrongful termination case, a wage and hour case, the revenue factor is completely moot. It makes no difference if we're talking about a company that's making the 60 billion or making 6,000. You're still going to have to deal with all of the things that come into play when you're dealing with any type of issue. So the ability to pay issue is different. So I have clients, because our clients typically are not the $60 billion companies,
right.
They're smaller than that, and they'll say, no, I cannot afford this lawsuit. Just the average, and I looked this up years ago, I should have looked it up for this podcast, but several years ago, the average defense cost for an employment case is about $135,000. It is very expensive. It's a lot of time on the lawyer's part. There's a lot that happens. It's a big endeavor to defend a lawsuit. So it's expensive. But when clients come to me and they're like, Renee, I cannot afford that. I don't have that type of, I've had clients, it's so sad. I've had clients that are working second jobs. Their employees have no idea, and they're pulling money out of their homes, their, HELOCs, in order to pay payroll, to meet payroll requirements. And now they're stuck with this, $1 million or $500,000 lawsuit. And they're like, I can't pay for this. If you say that, that doesn't end the conversation. That doesn't end the litigation, even if it's absolutely true. The plaintiff's bar has every right to go into every financial record of that employer. It's a really horrible experience. In fact, a client I was just working with, they were about to go to trial. I got thrown in at the very, very last second, and he couldn't afford anything. And so he filled out these forms. They were asking him how much silverware he has. So, because you go into personal assets too. So it's such a horrible process. But if you have these, these tax forms that show that you're making good money, you're never going to be able to get away with it. So, I mean, you really need to have nothing. You don't own anything. You don't, there's nothing that you can use to fund this lawsuit. So it's brutal. It is so brutal out there.
So, and that's really good information, because our, the listeners that we have are going to be smaller size businesses. And so no matter what size they are or how small they are, they're still going to be hit with the same dollar amount, the same types of cases and everything as these big conglomerates. And they're going to be stuck in these tough situations. So I'm really glad that you explained that for our listeners.
Yeah.
So then the next big question is, what are the top 5 mistakes that these companies are making? Because obviously we want to prevent against them. Right.
So it's hard to come up with the top 5 because there's just so many mistakes that companies either make or can make. Unless you are an employment lawyer and do this day in and day out like I do, it is literally impossible to prevent, every possible scenario that will keep.
Way to make a positive impact right there, Renee. Like, yay!
I know, it's so hard. I feel so bad for my clients. All my clients know this. My heart breaks for them because it's just they're working in a very difficult environment where, and it's funny. I've said this so many times to my clients that when I went years ago, probably when I was in high school, I heard the expression, no good deed goes unpunished. And I laughed because I'm like, oh, they made a mistake in that quote, because of course a good deed goes, it made no sense to me. Yeah. And now I don't know if a day goes by that I don't say that to my client. Now I fully embody that quote because it's true. It's like you do everything for your employees, like your heart and soul is just to have a wonderful company and to provide well for your employees and create, these widgets that you've been out to create. And you still get in trouble. You still have these employees that they would never sue me. This employee loves me, and they come after you, and it's awful. It's so disheartening. So the good news is, I'm being very doom and gloom, and I'd like to be positive, but the good news is that there are absolutely things that you can do to protect yourself to the extent that you can protect yourself in the state of California. So one of the things I would like to emphasize is dealing with employee complaints. So having been on the employee side for all those years before I started this firm, which I, by the way, co-own with my partner Alexis, who's like my other half. When we started this, we were both on the employee side, and I say this all the time. I can assure you that no employee ever came into our office and said, I was working for this company and I had these concerns and these issues, and I brought it to my boss's attention, and they were so concerned about me, and they validated me and they supported me. But you know what? I want to sue them anyway.
But I still want to sue them.
Yeah. That has never ever been the talking points. It's always, I had a problem, I made the complaint, nobody cares, nobody did anything, they swept me under the rug, nobody values anybody at this company, now I want to take them for everything they have. That's usually the theme of where these lawsuits start. So, and not every lawsuit, but that's a vast majority. Right. So if you have an employee complaint, and the problem is that sometimes people complain. That's just human nature. People complain about everything. And so when you go into the workforce, it doesn't change. You don't all of a sudden become a, happy, positive
go lucky, nothing's wrong, rainbows and ponies.
I'm just so grateful to have a job where I get paid. That's not usually the feeling that people have. So people will complain, and that's fine. You as an employer, if you have employees working for you that are supervisors of those employees, they need to be trained. very specifically on what to listen for. So, most people won't say to you, I feel like I'm being discriminated against, or I feel like I'm being harassed, or I feel like this is a hostile work environment. That's usually not what people say. They say, I feel like I'm being treated differently, or I'm being targeted, or it's not fair because this person's getting this and I'm not getting this. Those are the things that you really need to listen for. Or this person's being really mean to me, or I'm not comfortable, I don't feel safe. I mean, whatever it is, and it's your job as the employer, or to train your supervisors also, if you have them, to listen for that and then to know what to do with it. So in California, there's a legal obligation that you have to do an investigation for any complaint of harassment or discrimination. And so that it can be very expensive. I think there's many times where an internal investigation done by your, if you have HR, office manager, even you as the employer, there's a time and place for that where it's appropriate, and it's obviously much cheaper than bringing in an employment lawyer to do an investigation. But if it's a very small company, if the complaint is about you or is about your HR person, then right, you're conflicted out. So you need to really have that understanding of what type of investigation to do, and what, who you should be talking to, and that's a really big part of this. So not addressing employee complaints, I can assure you, if you don't address it, it's not going to go away. Nothing goes away without being dealt with, and it's just going to get worse and worse and worse, and then more people get involved in it, and it just becomes this nightmare. And then if it turns into a lawsuit and you did nothing about it, that's really, really bad. But like there's, I just got I did an investigation very, very recently for a client. The employee embezzled money from my client, like legitimately embezzled. I have so much documentation to show this. So we brought in, a accountant and a bookkeeper to do all the investigating. We worked together. We wrote a very extensive investigation report. We terminated her based on the findings of the investigation report. And then all of a sudden, about 3 weeks ago, we get a letter from the lawyer that she's suing, which is horrible. It's like, talk about adding insult to injury. Like they're reaming and reeling from the effects of just having all this money taken from them, and now they're having to defend a lawsuit. So I'm like, don't worry, we've got this. So we wrote I think it was about 100-page response. I think it was like 12 pages of substantive response that kind of outlined everything that happened, and the rest of it are exhibits. And I said, the police are involved in this. We took this very, very seriously. That I have a very good feeling. I mean, obviously, I'm knocking on wood. I can't guarantee, but I have a very good feeling that case may not get anywhere. Because once that plaintiff's lawyer sees something like that, plaintiff's lawyers, what people need to understand is that plaintiff's lawyers are working for free. They are not collecting a single penny from their clients, and they're working 100% on contingency. So they only make money if there's some sort of settlement or verdict, and they get a percentage of that, 30 to 40, 50%, depending on what the arrangement is between them and their client. So it is not in the plaintiff's lawyer's best interest to take a case that has absolutely no legs, that's not going to get them anywhere, because they're putting in as much time and money and energy as I'm putting into the case. They are also, I'm billing at an hourly rate, they're not. So it's really, really, really important to try to take all of the wind out of their sails at the get-go before it turns into anything. And so many of these lawsuits start as pre-litigation. So nothing's been filed in the courts. In this case, nothing had been filed. So if I hear back from them, I'll be shocked. Stay tuned. Who knows? But so that's why investigations can be extraordinarily powerful. Just to knock it out before anything really happens. So that's my first
complaints. Employee complaints, take them seriously.
Take them very seriously. Yes. Don't just say, oh, I don't have time to deal with that. And I can assure you that when you became a business owner, you weren't thinking, oh, I'd like to be a kindergarten teacher and deal with, all of the conflicts amongst people and making sure that they eat their lunches when they're supposed to eat lunch. I mean, you don't think about that stuff. You're just trying to run a business, but this is quite literally what you need to be doing as a business owner. So it is not for the faint of heart. So number one, I'll try not to spend so much time on the next four. The next big issue, and the next two kind of are very intertwined. So my second one is misclassification. So dealing with independent contractors versus employees, and exempt employees versus non-exempt.
California loves that.
So I am the first. I love California. I grew up here. I was raised here. I will probably never ever leave because I refuse to take the bar ever again anywhere. So I'm very committed to the state of California. But I have to tell you that I'm the first person to knock California for all of these insane rules. This independent contractor law did not start in California, and I'm very happy about that. It actually started in Massachusetts. If you want to direct your anger towards the state, it's not California this time. Most states have followed this new rule, and I say new, it's funny, it's not so new anymore. But this rule came down as a Supreme Court case in 2018. It was called Dynamics. We talked about this endlessly, and there's, you could Google the heck out of this thing. It's all over the place. Dynamics started as it was the gig economy, and basically just knocking out the whole prior rule about independent contractors, which used to be this 1985 case called Borrello, 85, 87, something like that. And there were like 11 factors for Borrello, and you can really finagle it. Like, you can just kind of play around with it. It was kind of what, if you can prove most of it, probably get away with it. And there wasn't a lot of teeth to it. Then Dynamics came and created this 3-part test. It's the ABC test. And without going into, I could talk about that for 2 hours alone because there's so much detail. But all you really need to know is that the B part of the test has made it almost impossible for people to be independent contractors anymore, because the B part says if the worker is in the same industry as the hiring entity, they are an employee. So if you think about it, you hire anybody to come into your office to do any work for you, they're almost always going to be an employee because they're in the same industry. If you bring a plumber into my law firm because we're having some plumbing issues, they have nothing to do with the area of law. That's a legitimate independent contractor. So, and it's almost that extreme. A graphic designer, they could be an independent contractor if they're doing marketing materials for a business they're not in the business. There's since Dynamics, it got codified into AB5. AB5, then there was a carve out. It's this rule called AB 2257. That's what we usually are working with when we get these questions, because there's all these exceptions. There's this really big exception called the business-to-business exception, which has 12 criteria. Every single one of the criteria have to be met. It's extraordinarily difficult to meet this test, but it's doable. I think I've successfully thrown that together maybe twice. And because it's tough. I mean, the fact is that California lost out, and as did every state, on billions of dollars. I think it's like $7 billion of payroll taxes. So of course it always comes down to money, and that's why they're trying to make everybody an employee, is to be able to capture that money. Misclassification is no joke. If you are caught by the labor board, and if you have an independent contractor on the books, then there's a red flag there right then and there. And if they end up auditing you, or if there ends up being some sort of lawsuit for misclassification, then they look at everything. Because if they decide to designate that person as an employee, well, now you're going to have to be paying back any possible overtime. If you didn't do timekeeping, which you would never typically do for an independent contractor, then there's penalties for that. You didn't give them their meal breaks. If they did take their meal breaks, then they're gonna assume that you didn't, because you can't prove it. So unless they're exempt, and that's a whole other conversation, then that you're still going to have inaccurate wage statements and other types of penalties that are applied, but not to the degree as if they should have been a non-exempt employee. Quickly, the exempt versus non-exempt is a whole other conversation, but if you're exempt, that means you're salaried. And in California, as of January 1st, it changes every year. It's a 2-part test. They have to be making at least $66,560, and they have to meet this authority discretion test of how much authority and discretion they have over their job, which is it's a duties test. They have to fit into a certain exemption. It's not that easy. It's not so simple. Everyone should always be defaulted as a non-exempt, an hourly employee if possible, because you can't go wrong. Even if they're making $200 an hour, that's fine, as long as you're doing all the things you need to do in terms of timekeeping and giving them their meal breaks and rest breaks. Which brings us to the third mistake, is wage and hour rules. And so they kind of are all mixed up, the misclassification wage and hour rules. So wage and hour rules, there's a explosion of labor board claims about this right now. It's insane how many things are coming up about this, but the rules are so black and white. You either did it right or you did it wrong. There's nothing in between. And having your meal break before the end of the 5th hour, taking 2 10-minute rest breaks in an 8-hour span, sometime within the first 4 hours. It's very, very, very specific. Overtime is very specific. There's just a lot of rules that surround wage and hour. And if you make that mistake, we have PAGA and class actions that are, in the 7 figures easily. It's outrageous. It is outrageous, the liability, depending on how many employees you have, what the percentages of the violations. It's a whole analysis you have to go through.
How far back can somebody go on that?
So technically 4 years, most likely 3 years. Never more than 4 years. 4 years is if you can show some sort of malice, like if the employer is just really trying to make the employee just work for slave wages or whatever, then that could be the 4-year mark. But I've never dealt with 4 years. That's incredibly rare. It's 3 years is what you have to be thinking about. But 3 years, I mean, it adds up when you're talking about hundreds of employees potentially. I mean, my restaurant clients who they're like a turnstile because, one of my restaurant clients, they're right next to a college campus. So these kids have been working for them for 2 months here, 3 weeks here. They are all thrown into that class. So there is a new rule. I don't have time to get into it today, but there is a new rule that just came down. Thank goodness. It's probably the first employer-friendly rule that's come down in a long time, which chips away at PAGA. So PAGA is the Private Attorney General's Act. It's a whole world in and of itself, but it is an absolute miserable thing when an employer gets stuck with a PAGA action. And now they've made a lot of changes where they've chipped away at it, where now there's curing possibilities and you can fix things and it offsets the damages. And my hope is that it's so chipped away at that employee attorneys will stop bringing these actions because they are so detrimental to employers. It's like a nightmare. So so wage and hour rules, making sure that you're doing the proper timekeeping, understanding it there's just no way around it. And that's not my favorite aspect of what I do because there's no, I love to argue and fight. That's why I became a lawyer. And there's nothing either you did it or you didn't do it. So it is what it is. It's tough. I mean, there's a little bit of arguing room, but very little. Next thing quickly, there's a thing that no one's ever heard of typically called the interactive process meeting. All you need to know, interactive process is a fancy, unnecessarily fancy way of just having a conversation. And when an employee goes out on some sort of medical leave, when they come back, they have to bring a doctor's note. It has potentially restrictions on it. You have to have compliant job descriptions to be able to figure out what the essential duties are and to kind of cross-reference the restrictions with the job duties and see if there's any accommodations that need to happen. Really, really important. If you don't have it, there's an entire cause of action called failure to engage in interactive process, failure to provide reasonable accommodations. A lot of lawsuits about this, and we, on the plaintiff side, my partner and I used to depose HR professionals all the time, and we say, well, what do you know, did you ever do the interactive process meeting? They're like, I don't know what that is. And that happens all the time. I mean, it's not like typical thing for people to know about, but holy cow, are there consequences if you don't do it? So make sure that you...
Well, and that sounds like that whole process starts with having a really good job description and knowing what tasks that job actually needs to do and what the requirements are, because if you don't have that, it sounds like the rest of that process goes downhill.
That's 100% correct. So essential duties on your job description and physical requirements are two of the more important parts of that. And to figure out, can they still do the job given their restrictions, looking at the essential duties, and then what types of, if the doctor says they need to sit down every 10 minutes, but it's a job where there's nowhere to sit, it's a stand-up job, it's physical labor, I mean, that's really relevant. So, but as I tell my clients, as an employer in California, you're not really required to move mountains to make these jobs work for somebody who's on some sort of restrictions or in some sort of disability, but you kind of do have to move mountains. I mean, you really have to figure out you have to get very creative, every possible way of trying to get them to still be able to earn wages, even under this disability. It's tough. So interactive process, just know about it, and recognize that if somebody comes back from disability, you don't just throw them back into work without talking to them, and you need to make sure that you really... What's that? Yeah, that's what I was dealing with right before this podcast. Is an employer that the employee's out on pregnancy leave, and he called me. He's like, so we want to fire her. And so as soon as she gets back, she's like, we gave her 12 weeks, so we could fire her right when she gets back. And I'm like, no, we're not doing that. Right. So that, I mean, it's tough. Last mistake is not terminating fast enough. And so, if you have a gut instinct about somebody, certainly before you hire them, if you have a gut instinct, do not hire them. We always say hire slow and fire fast. I mean, with the caveat that I've dealt with a lawsuit of an employee that worked for the company for 6 days, and they still had a lawsuit with, $500,000 of damages that it didn't end up settling at that, but it doesn't really matter. And this probationary period that people think is so protective has absolutely no meaning whatsoever in terms of protecting the company from any type of wrongful termination. It has meaning for purposes of, benefits, like when you're actually going to be eligible to get medical benefits, your 401k participation. There's eligibility requirements for that as well. But in terms of like, because we get calls like, okay, it's day 89 of our 90-day probationary period. We don't really like her, so do we have to fire her today, right? I'm like, if you fire her today, if you fire her tomorrow, if you fired her 2 months ago, like it doesn't really protect you. But the less time that they've worked for you, the less damages, the less mistakes necessarily that they could accuse you of. I mean, there's not that, you don't have like years of like buildup of examples and incidents. So it is good to get rid of somebody quickly if you do it properly. So termination, I mean, I tell my clients all the time when they sign up with us to do compliance work, I'll say to them, look, I'm getting you all set up. We have your handbook. We'll get you all your onboarding documents. We have everything that you need to run your business. And if you never want to call me again, I get it. I know nobody wants to deal with lawyers. It's expensive and annoying. But please call me before you terminate somebody, or if somebody goes out on a medical leave, or when they're returning from their medical leave. That's where there's the most possible, exposure and liability. So that's when I'd want you to call me. So those are all the 5 mistakes, but the number one thing, if you take away from nothing that I just talked about today, the most important thing that you need to remember is to document everything. Like everything. If you don't document it, it didn't exist, it didn't happen. The conversation you had where you counseled them 10 times about not coming to work late and being a good employee and not having an attitude, if you didn't write that down, then when push comes to shove, you finally decide to terminate them, they bring a lawsuit, they say, I was the most incredible employee this company's ever had, they were so lucky to have me, and then we're like, you were late 25 times in a 2-month span, and you had such an attitude, and like, well, where's the documentation to show that? They're just making up an excuse because they don't want to have to admit that they terminated me wrongfully. So document everything. It's so incredibly important.
Well, and that other thing that you mentioned it multiple times, but people need to realize that 90-day probation period really doesn't mean anything, because I've heard that a lot from employers, like, oh, it's okay, it's 90 days. Or the other thing I love is, oh, it's okay, we're an at-will state. No, not what you think it means. Please don't try to use that.
So I have that conversation a lot where people call me like, okay, so I want to fire this employee. I'm like, well, let me ask some questions. Well, why are you asking me anything? It's at will. And I always say if at will meant at will, I'd be like, at the beach for half my day because I'd have nothing to do. It would not be what it is now, I can assure you. At will. So it's at will with a big, ginormous asterisk next to it. Yeah, because just to for 2 seconds here, because I think it's so important, is that if you are 100% allowed to terminate an employee for any reason, just like it says at will. They have an attitude. They're not performing properly. They don't understand what the tasks are. They're coming in late. They are goofing off. They're on their cell phone too much. Anything. Those are all totally justifiable reasons to terminate somebody. The problem is if you don't do it properly, you don't have all the documentation, you don't have the write-ups, the performance evaluations, the performance improvement plans, all the things that you can do, all the tools that you can have in order to properly terminate somebody, and then you terminate them, they're not going to go, I can assure you they're not going to go to the plaintiff's lawyer and say, I know that I had this attitude. I know I came in late all the time. I know that I, raised my voice too often. I was on my cell phone. I was goofing off. And that's why they fired me. It's never going to be that. They're going to say they fired me because and then name the protected class. And pretty much everything, it's gender, sexuality, age, anyone over 40 years old is protected for, from age discrimination, nationality, anything, and that's protected, which is pretty much, every single year there's a new protected class that comes in. Reproductive decision making is one of the newer protected classes. So if they happen to talk about, oh yeah, I got my tubes tied last weekend, and they just have that conversation, somebody hears them, then they'll say, I wasn't fired because I was late all the time and I have an attitude. I was fired because I was talking about getting my tubes tied. I know that the owner of the business has a really big problem with that because they don't believe in that, and so that's why I was fired, and that's a protected class. So now you have to prove, I could care less what you do with your tubes. I don't know what you're talking about. I didn't even hear you say that. The reason I fired you is because you're a really bad employee. But if you have nothing written, then it's their word against your word, and now you have to prove the negative. You have to show that you could care less about, their reproductive, abilities, and it's so hard out there. It's so hard out there to be an employer.
Wow. Well, I'm really glad that we talked about the at will, because I hear that from employers all the time. So, okay, the other thing that I hear all the time is, Oh, yes, I know this is all important. I know I could get in trouble, but I just don't have the time to deal with it. And I've got more important things like running my business than dealing with all of this. What would you say to that employer? Because I'm sure you hear that a lot.
I hear that all the time, and I meet that with nothing but understanding and compassion because I get it. I mean, I'm an employment lawyer, but I also run a business and I have employees and I have to deal with a lot of these issues too. And I don't want to deal with a lot of this stuff. I just want to run my law firm. I just want to practice law. I don't want to have to deal with, whatever issues are coming up and dealing with vacation time and thinking about all this stuff. And, if employees aren't getting along or whatever, it's a hassle. But what I tell my clients is, dealing with it, not choosing not to deal with something, it's impossible just to say, I'm not dealing with this, put your hands over your eyes and ears and say, I don't have time for this, because it'll rear its ugly head somewhere. And if it rears its head in a lawsuit, the amount of time and money you will be dealing with this is so not worth the just dealing with it as it's happening. So when clients call me, and this happens all the time, when clients call me like, okay, I want to fire this employee, and I say, what do you have documented? They say nothing. And I'll say, well, let's talk about it. Tell me about this employee. Tell me what's been going on. And then they tell me. And I say, well, it's very easy that they're going to say this, that they were retaliated against, or that, you're saying this because of, they just came back from this medical leave 2 months ago. They could say anything. They say, no, but it has nothing to do with that. I don't want to deal with this. I don't want to deal with this. I say, let's just go slow. Let's start writing them up for all of these issues, these legitimate issues that you have with that employee. Let's start documenting it. Let's start dealing with it. And then you start to deal with all of that. You start to get a stack of documents to prepare to protect yourself, versus just saying, no, I don't have the patience, I don't want to deal with this. You fire them, and now we're dealing with discovery and depositions. And you're dealing with this employee for 3 years, like literally, like beginning to end of a lawsuit could be anywhere from, if you settle early and you go to mediation, maybe a year. That's early, but it could be 3-4 years. It's endless. So it's just, as much as I feel so bad for my clients, because I really understand their feelings about it, and they're so frustrated, but it's just not worth it. It's not worth just doing what's easy right then, thinking that you're saving yourself time. You're not. It could cost you. I just settled a case a couple of weeks ago for a client that I've gotten so close to. I love him so much, and his reasons for firing him were so incredibly justified, but he was in a protected class and he didn't have enough documented, and now it's like he's easily $100,000 into this thing, and with the settlement, everything. It's just, and I said to him, I'm like, please, 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 now that he found me through litigation, don't ever fire somebody without talking to me first. It's just not worth it. So now he gets it. I mean, our best clients are always the ones that have been touched by litigation in some way, because they understand how serious all of this is.
Yeah, pay for a couple hours of your time to get things squared up ahead and save yourself $100,000 to $250,000 down the road. That sounds like a cheap investment.
Just document. Even if you don't hire me, as long as you document everything that you do, then if God forbid you get into this situation, you'll be miles ahead of where you would have been had you not documented anything.
That's so great. Wow, I am just totally shocked at how much information that we just got in on this podcast. I can't believe it. I'm sure listeners are going to be like, wait, pause, replay that section. Let me write down all of these notes, because you gave so much in-depth content. It's amazing. So thank you so much for your time. And if somebody wants to get a hold of you and talk through maybe a situation that they have, where's the best way to reach out to you?
Oh, thank you for asking that. So my office is in Calabasas, but we practice law in the entire state of California. And since COVID, with all these employees now going remote, so now we don't practice law in those other states, but we certainly can give, just basic advice for how to handle employees in other states. So the fact that I'm here, I have clients I've never met in person ever, but you can call me at my office, and that number is 818-591-6724, and my email address is Renee, Renee, at my law firm's name, Workwise Law.
Perfect. So we'll put that information. We'll also put your LinkedIn in the information for this podcast, so that if anybody wants to get a hold of you in smoke signals or any way possible, they can get a hold of you and get more clarification or more advice on any of the information we gave. Thank you again, Renee, so much for joining us today.
Thank you for letting me talk. I so appreciate it, Erica.
Yes, so much. It's been a plethora of knowledge. And thank you so much for listening and joining us today. I hope you learned as much as I did. And you're going to be hitting that replay button and getting all those nuggets of information. So join us next time. Again, my name is Erica Dill, the host, Operationally Up. Thanks for joining us on Building Up Your Podcast, and we will talk to you soon. Thanks. Bye.